happy to be joined by Bill Hulsey from Hulsey Law. Bill, we have often talked about different kind of things sports-wise on the show. We have never really talked about patent law or what the overall overarching thing, and that is what you do. And it's very interesting in times like these where there are, because everybody's online, everybody's thinking up new ideas every day, your life must have gotten maybe demonstrably busier because of people trying to do the same thing or similar things at the same time and names. So just kind of broad spectrum. If I've created something that I want to get a patent, a copyright, something on, should my first step be to come to someone like you?
Yeah. So what you need to do to protect what you've created is first to have created it. One thing that's not a good idea to try to approach an intellectual property attorney with is ideas that haven't been formed into an actual product, or at least a set of drawings for what the product would do. So getting that on, at least on paper, is a key first step. If you can get it on paper, then we can start working with you and help you get to the point where you can identify what patents are out there and how they might affect or not your ability to secure a patent for what your invention is, as well as considering the protection, identification, and protection of brands that would go along with a particular product. I know years ago I worked for a company called Big Play Scoring, and what we did was obtain about a half a dozen or more patents on technology that was developed that allowed the company that had it. There was a company called Dual something. It was that wasn't our client, but the purpose of our client was to award points for the big play in a game. And he found statistically that there was a relationship between the team that did the big play and the team that won over a season. So even though the scoring was not on the particular scores that actually took place, the technology, Big Play Scoring, you can find it on YouTube, was about awarding points and betting in and seeing the correlation between the points that the system would award for the big play and the long-term capability of the team to win game after game. So that was something that we do. We got several patents on that. If you've got a new technology, something that you want to hit the market with, there are a number of ways to protect that. The utility patent is one way that protects what something does. Another is if you have, let's say you have a new design for a football, and that design would be something that we could protect by what we call a design patent. But in the other areas of intellectual property, trademarks are used to protect any way of identifying a product or service in a market. So if you have a new logo for a sports team, if you have a new name for the team itself, if you have a collection of moves that you want to protect, you can do that and obtain trademark protection for those particular moves if they are unique. Now, the other area that you can pursue is copyright. Copyright's a wonderful area. The technology that the music that sports teams obtain, market, that can be protected by way of copyright. So there are a lot of things that you can do. And intellectual property is one of those things where pay me now or pay me later. And by that, I mean, if you don't go ahead and become aggressive and pursue your rights, there'll come a time when you look back and you say, I wish I had And if you didn't do that, there's some things you can fix later on, but a lot of things you can't fix later on. And that is the reason that we want to go ahead and file and obtain protection as part of the initial steps that a company takes to go into the market.
Well, it's interesting that you brought that up because I had this question for you anyway. Tell me where I made the mistake here. 2 years ago, I created a podcast on this network called The Triple Option. Okay. I searched far and wide and made sure that there were no other triple option college football podcasts, and there were not. So, coming from the world we do it, like in radio, there's tons of shows called The Blitz or, the Morning Zone or whatever. So I didn't really think anything of it. Like, it's just one of those things that was. But YouTube is a little bit different because it's not local. It's international. I mean, it's everywhere. So I didn't really take that into account. Then a year after I started that podcast, Urban Meyer, Mark Ingram, and Rob Stone started one under the umbrella of Fox Sports, which I don't think I need to tell you has a lot more money than we do. And so our algorithm was slowly ticking up. But when the triple option with Urban, with a Heisman Trophy winner and a 3-time national championship winning coach burst onto the scene, our algorithm got absolutely shot. So where did I make my mistake in that so that does not happen? Because I thought about legal recourse, and I thought ultimately I'm going to spend a lot of money on an attorney. This hasn't really been going that long, and they're just going to maybe give me a little bit of money to buy it, or they'll just scrap it and go, we don't care. We don't want to spend the money. We'll change the name. But where did I go wrong in not protecting my intellectual property of the name of that podcast?
So you found a conflicting name in another podcast.
Okay. Well, they came after. So I was there. There was no conflicting name. They didn't even look, or if they did, they're like, this guy will go away.
Did they say that you infringed the copy, the trademark of theirs?
No, they didn't even say anything to me ever. It just killed our algorithm, and we decided to scrap the name. So because we came first, we were there a full year before they started.
Okay. Well, two things. One is, if you intend to go into commerce with a name like that, it's a really good idea to do a trademark filing for that product, that digital product that you're offering. And when you search on the database of the U.S. Patent and Trademark Office. The internet's not going to help you. So looking for that on the internet is something that you may or may not find. And that's dependent upon whether the owner of whatever mark has taken the time and effort to brand and commercialize and advertise his product. But if you don't find it on the internet, that doesn't mean that it's fair game. What people do is they have the plan of filing for a trademark. So the triple option that you want, that's something that filing, determining if that mark is available, we do what we call is a knockout search. So all the trademarks that have been filed, not granted, but filed, are on the database at the U.S. Patent and Trademark Office. And that database is uspto.gov. It's a government database. And on that database, you can do a search. And that search is a multifaceted search. And you can specify the types of things that you want to know. The thing that you also want to do is, if it's available, go ahead and file for trademark protection. Because what happens when that occurs, the application goes to a trademark attorney at the U.S. Patent and Trademark Office. And that attorney, whose job every day of the week is to search trademarks, that person knows how to go into the databases and find things that average people don't have the ability to do. So helping getting, and all of that occurs when you file for the trademark. Now, if it's on file and somebody uses it and they come in after you, you have the ability to send them a notice that you have prior rights to that trademark. And if it takes about a year for that trademark to work through the procedures at the Patent and Trademark Office, but if you go through those, you have a registered trademark, and on your mark, on your logo, on your screenshots and branding, you have the ability to designate the mark triple option with the circle R, which indicates that you've obtained a federal registration for that trademark. Now, there's a challenge with a mark like that, because when you submit your application to the trademark attorney, to the trademark office, there's certain things that will prohibit you from getting a trademark. One of those is that the trademark itself is not what they call statutory subject matter. A trademark can be had for anything that is not descriptive. Well, a triple option may be considered by an examiner to be descriptive, and if it is, you can't get it registered because it's a description of something that occurs. On the other hand, if you're actually getting a trademark on the podcast is not a triple option. That's what you're calling it. Mm-hmm. That is something that you can get a trademark for. So the main thing is to make sure that the mark is clear, that someone hasn't sought to protect that mark on their name, on their product. And if so, then you file. It takes about a year, like I said, to go through the process. And in terms of what it costs to deal with a conflict and pay lawyer hours to address that conflict, the act of filing the trademark is much cheaper, much more satisfying, because you know where you are, because you've looked at it, your attorney's looked at it, the trademark attorney at the Patent and Trademark Office has looked at it. When it's gone through those checks, then there's a good chance you're going to get that trademark and have it issued. Now, if it issues as a registered trademark, there's a period within which they post and make sure that the person who might want to contest it, who may have used or filed for the mark before you did, may have prior rights. And there's a period of contestability is what they call it. In that period of contestability, somebody who can legitimately say that they have prior rights to the mark can come in and challenge it. But after 5 years, your mark achieves a status called incontestability. And what that means is that if someone comes in and says that they had the mark before you filed it and waited for 5 years in order to assert their rights against you, well, you're going to get that mark and you're going to keep that mark. Mm-hmm. So that's something that you have to factor in on what you're doing. And what that means is that you want to file as early as possible, because when that filing occurs, you start clicking off that time on that 5-year contestability period if you get the registration.
What are some of the mistakes that people commonly make when they come to you about something, or what's a common situation that you deal with on a daily basis?
Yeah, there are things that I can fix, and there are things I can't fix. Mm-hmm. One of the most important things that you have to know, let's say that you have created or invented a patentable invention, a patentable sports invention, whether it's a ball, whether it's an implement like a hockey stick or a bat or something. The patent office, the patent law, has a requirement that you file for protection not later than 1 year after the device is offered for sale or made available to the public. Well, that's a clock that the minute you put it out on the market, the minute you put it on a website, the minute you go to somebody and say, I will sell you this for X dollars, that clock starts ticking. And if you don't have your patent application on file before that year is up, you're not going to get the patent. Not only that, if your product is something that is protectable, that has a market outside the United States, if you don't do the filing before you make it into the market, then in places like Europe and China and elsewhere, you can't get the mark. That publication filing before that occurring before you file for the patent application is something that will prevent you. There's not a grace period in most countries other than the United States, but there is a 1-year grace period in the United States. And so the minute you have something you want to protect, if the U.S. is your market, you've got a year to work with. If not, you're going to have to get it on file before you advertise it, before you talk to people about licensing and working with you on that particular product. So those are some things to think about. As far as trademarks are concerned, I think it's a good idea, the branding, to do the searching and validation that you're not infringing somebody else's mark in a stair-step way. First is to do the search yourself. Use Google. See if anything you can find anything on Google, and if you can't, that's a good, strong indication that at that point it makes sense to contact an attorney who works in this area, because he can ratchet it up to a higher level, and from that higher level, he can do the searching and the registration of your mark. That's what you want to do. You don't want to waste time filing for applications for trademarks that have not at least been vetted by you. But that's something to take into consideration. And then the other thing that is important, and that is that you've got any product, just like football teams have secret plays that they can communicate with their players. Well, you've got secrets that you need to have in order to protect your place, or to have an element of surprise in the market where you're going to announce a product. Well, those are called trade secrets. And understanding the protection and the management of trade secrets is important for startup companies and for new products.
Yeah, I was going to ask about trade secrets and protecting those. Those are things that kind of easily get out if they're not protected, right? Because people like to talk about. You're never going to believe what we've got here. Look at this new thing, right?
Bad idea. So, so a trade secret is an interesting piece of intellectual property, because there's no filing with any state or federal office that you have to make in order to establish a trade secret. And the definition of what becomes and is a trade secret is it's a very broad definition. A trade secret has 3 things that you have to keep in mind in order to say that you have a trade secret. One is that information, and it can be anything. It can be a software program. It can be a recipe. It can be a way you could put things together. It can be business relationships. Anything that is not generally known, that provides the holder with a competitive advantage in the marketplace. Think Kentucky Fried Chicken. That recipe of 57 herbs and spices has been a trade secret for well over 100 years. It's something that is not generally known. Kentucky Fried says nobody knows how to make the recipe like we do. The recipe gives Kentucky Fried a position in the marketplace, a protected position in the marketplace. And then the last thing for a trade secret is something that provides to the owner a financial benefit in the marketplace. I'll never forget, 20 years ago, I was watching television in Nashville, and it was a news story about how Kentucky Fried moved from a house for its corporate headquarters to a building for its corporate headquarters. And Colonel Sanders, who founded Kentucky Fried Chicken back then, Colonel Sanders was shown in the little news clip leaving the house and going into a Brinks armored car to move the recipe from the old location to the new location. And when he did, he had handcuffed the briefcase that held the trade secret for the Kentucky Fried Chicken, was handcuffed to him. So he went into the armored car, and they took him and the briefcase and the recipe to the new location and put that recipe in the safe and locked it in the new new location, because that's the third step in having a trade secret, and that is that reasonable measures had been taken to assure that the confidential information stayed confidential. So it's not generally known. Recipe fits that. That provides the owner a competitive advantage. Coca-Cola is a trade secret.
Mm-hmm.
Kentucky Fried is a trade secret. That information gives the owner a competitive advantage, and then reasonable efforts of keeping that information trade secret. And there used to be no statute, federal statute, for trade secret. But about 10 years, 20 years ago, the federal government established a federal statute. And the federal statute identified trade secrets is exactly what I just said. And so it's an important right, because if you can't protect something by way of patent or copyright or trademark, looking at what your options might be regarding trade secrets. And what's important there too is that one of the ways of keeping the trade secret is having employee agreements, so that if somebody has access to that trade secret, they covenant by virtue of signing a non-disclosure agreement that they won't share that secret with anyone unless they're previously authorized to do so. So keeping it secret is an important part of how trade secrets work.
Yeah, and I guess if I was one of the high-level executives at Kentucky Fried Chicken, and another, my contract's up and I leave, I'd have to memorize it, right, to even try, and that seems a lot. And then you'd probably get caught, wouldn't you, if you were just making?
Oh yeah, no question about it.
Yeah, you'd probably get caught.
That's a really, really great question. Years ago, Coca-Cola had a new chief executive officer. He made a mistake as in his first year of being the chief executive officer, and it cost the company a tremendous amount of money and a tremendous amount of prestige. You might remember it. They came out with a product called New Coke.
Oh, yes, I do. I was very young, but yes, I remember it.
And that product was a real flop.
It was disgusting.
It was disgusting, but that same guy who did it, the guy's name was Roberto Guizetta. He was a Cuban who came across on a boat to Miami with nothing to his name, and he got a job at Coca-Cola in Atlanta, and he went from being an immigrant to being the chief executive officer of Coca-Cola. But along the way, as he made his way up to the leadership of Coca-Cola, he wrote a book. And he wrote the book was entitled, "I'd Like the World to Buy a Coke." There was a commercial back then, was "I'd like to buy the world a Coke." Well, he wrote the book, and you can find it. I'd like the world to buy a Coke. And in that, in the opening of the book, there's a timeline that shows from when he was a penniless Cuban immigrant to the time that he was chief executive officer. And in the last years of his ascension to chief executive officer, in that timeline, they show the day that he received the Coca-Cola formula, because there are only 5 people in the company who are entitled to know the Coca-Cola formula. And so they keep that formula as a very tight trade secret within the company.
I've been to the Coke Museum in Atlanta, and they have what is supposed to be like a recreation of the original recipe, like the way he wrote it down. Mr. Pemberton that made Coke. But it's like blurred out. Like, so they said, like, they still have it. Like, it's in, you safe, like the original paper that he wrote it down on, or one of them, but they like blur it out. So it's like, it just says like recipe on top of it. And then it's blurred out so that everybody who comes in can see, like, look, this was just, it's real, on a paper for trade secret. Yeah. This is the trade secret. It's on a paper. It's somewhere else now, but the original, we still have it for posterity, somewhere. And, but yeah, it was like blurred out. Yeah.
Same as Kentucky Fried. They keep it locked up.
Yeah. I think the only thing you see is like water. Like, it just says water, because you would know that there's water in it. Like that wouldn't be too hard to figure out. But the rest of it is all, is all a mystery. Bill, this has been really entertaining for me and really educational. I'm fascinated by these kind of things.
Yeah.
And so if people do have these questions, how do they get in touch with you guys? You have offices across the South, I know. And how do they get in touch with you to say, like, hey, I've got this thing. I've been working on it for a while. I'm ready to go and bring it to market, but I got to make sure I'm protected.
Thank you very much. Yeah, the best way to start it is to go to our website, and there are links that you can click on the website. The website address is www.hulseyIPlaw.com, and that is HULSEYIP for intellectual property law, all one word, HulseyIPlaw.com.
Bill, this has been so great. It's great to meet you. I hope we get to meet in person someday. And I hope that the next time that I come up with an original podcast idea, I'm smart enough to remember to call my new friend Bill.
Okay, we'll lock you down.
All right. Thank you. Right. Thank you so much. If you've got that next idea, that next big thing, and you get it protected, HulseyIPlaw.com. That's the website. Bill, so great to meet you. We'll talk to you again soon.
Yes, sir. That's wonderful. Thank you so much for this opportunity.